All right, welcome back. This is the Colorado Energy and Carbon Management Commission. It's November 15th, it's 2:37, and we are now going to continue with the Gunnison Energy docket. Can I get the lawyers back in the room, Mr. McGowan, Mr. Foote?
Yes, sir, Commissioner.
Just quick question, Mr. McGowan, a note from the pre-hearing order, you had identified 10 exhibits, and Mr. Foote, I believe you had identified 2 exhibits. Do you guys have any concerns with me allowing those into the evidentiary record? Mr. McGowan goes first.
Not on our end, Your Honor. I'm sorry, Commissioner.
No objection here.
All right, then we will go ahead and admit those exhibits. And then I believe we are at that point in which, unless I'll give commissioners one last chance. Does anybody have any final questions? Because otherwise I'm going to close the record and then we'll start deliberations. Commissioner McGowan.
Thank you, Mr. Chair. I'm wondering if, so I've been thinking about transparency and communications and letting folks know that what you're doing is a good neighbor. And I hear Gunnison, and I understand that you have a good working relationship with Delta County. I'm not sure that the folks you've been hearing from today feel like there's a triangle here where communication is also going out to other people besides just Gunnison and Delta County and the commissioners or the local government designee. I realize that this is not our rules and we can't require it. But you know, when we have operators who will be within a disproportionately impacted community or within 2,000 feet of an RBU, it triggers a different kind of community engagement that to date, most operators have not found overly burdensome, I don't think. And it's letting folks know when you're going to be drilling, when you're going to be doing completions, when you might be doing flowback. Being transparent and sharing information. And I'm wondering if the operator is willing to set up some sort of system that would notify folks who sign up to be notified when you're going to be drilling, when you're going to be doing completions, when you're going to be doing flowback, and if there's an uncontrolled spill.
Commissioner, can I take a moment? I would need to confer with my client. I can't represent that until I confer.
That's fine.
Could you give us like a
confer with your client?
5-minute break? Okay,
yeah. Give
us a few minutes here.
Okay. Tell you what, folks, let's just, when McGowan revisualizes, we'll start back up.
Commissioner, give me 1 second.
All right, Mr. McGowan, you're back.
Yes, sir, Mr. Chairman. And after a robust conversation, Gunnison Energy believes that being a partner with both the commission and the entities in the communities is very, very important. And so in that vein, to your point, Gunnison is willing to, for a reportable spill applicable to the location and reportable spill, within that reporting period of time, they are willing to provide a one point of contact, a notification to one singular entity. So if that's CHC or if that's one of the petitioners, that would be up to them. And we would say the only request that we have is the burden needs to be on that entity to let us know. And otherwise, we don't want to have a situation where we report it or they say, well, that number changed or something of that nature. I mean, that's our concern. So long as the condition is that it's a reportable spill on the location and they provide us with the contact point within that reportable spill period, we are willing to reach out to that singular point of contact and let them know of that spill.
Commissioner McGowan, follow up.
I think that sounds reasonable, and it sounds to me like hopefully Mr. Foote has someone in mind who could be the key point entity.
And we don't need that defined today. There can be a dialogue following this. We don't even know where we're going with the application. All right, that was our opportunity for final question. I think that was a good one. Thank you, Commissioner McGowan. With that and seeing no other final questions, I believe it's appropriate now to close the record in this matter. So the record is now closed. The lawyers can unvisualize and listen in. We're going to move into deliberations at this point. Thank you both for your presentations. All right,
Thank you for
who's
your time,
antsy to go
Commissioner.
first? Commissioner Ackerman?
Thank you, Mr. Chair. I'd be happy to go first. I just have a few deliberative comments here. I appreciate the record as it was presented to us, had an opportunity certainly to review those documents in addition to the testimony that was given here today, and recognize the importance of these decisions, recognize the importance of how they impact our economy, how they impact our lifestyle, and certainly the localized impacts. That said, I wanted to make just a few comments, and I wanted to start with a bit of a non sequitur just to address the issue of high priority habitat for golden eagles, as it's been peppered throughout the documents and a little bit in the conversation today, and just make clear that there is no such mapped HPH in this project area. And, you know, philosophically, just as we work diligently to hold operators to protective standards within mapped HPH, as we support CPW's extensive and involved HPH designation process, it's equally important to not utilize unmapped HPH assertions to inhibit actions. And this parity in and of itself protects the integrity of the HPH process. I find no HPH concerns associated with this application. Further, you know, as I understand today's testimony and the materials provided, other proximate oil and gas operations, of which there are numerous, have not resulted in fruition of any of the concerns akin to those identified as possible by CHC. And our rules are intended to implement our statutory charge to regulate in a manner that protects public health, safety, welfare, the environment, and wildlife resources. Absent a deficiency under those rules adopted for those specific purposes, and absent anything beyond assertions that speculative events may occur that ultimately could have negative consequences, even though they have not occurred with previous oil and gas development in the valley, it puts us in a place that, to me, it's really difficult to postpone or deny this application based on the testimony given and the materials provided. Really, to the contrary, you know, the way I think of it philosophically, once again, is that withholding approval of an OGDP that is in compliance with this commission's rules due to the assertions that it may ultimately cause harm would be tantamount to approving an OGDP that's not in compliance with the commission's rules because it ultimately might have benefits. Those rules are there specifically to address the issues that have arisen today. And I do believe very much, as I stated, it's important to protect livelihood, lifestyle, and well-being and how we live here in Colorado, and that these regulations are crafted around that principle. Much of what's being asked by CHC really is simply further administrative effort along the same vein of work already being done by Gunnison Energy. And if Gunnison extended their work effort and analysis along those same threads, I think it's unlikely those efforts would change the outcome of their conclusions as provided in the materials. I also think it's unlikely they would change CHC's response to one of acceptance of this project. I am very empathetic to the issue of notification for folks who potentially may be impacted by events, and particularly those who make their living from the land. And so I'm appreciative of Commissioner McGowan raising this issue and Gunnison Energy's willingness to provide further incident information as outlined by Mr. McGowan. That's really all I have, Mr. Chair. But that said, I didn't hear anything today that put me in a position where I am currently in opposition to this application.
Thank you very much, Commissioner Ackerman. Well-articulated thoughts. I'll just weigh in ever so briefly that I'm in agreement with you. I also look at the record that's before us, and our staff did the job they're supposed to do in terms of reviewing the application and ensuring that all the standards have been met, and that a lot of the concern, in particular about like the concern about spills and harming irrigation water and all of that sort of thing, you know, our staff looked at that and concluded that the site design and site standards and design controls that are implemented here are addressed to ensure that those things don't happen. And so, you know, I rely on our staff in their analysis. You know, frankly, I don't know that I heard even the petitioner raise serious concerns about not meeting standards. And so I appreciate the notification requirement as well from Commissioner McGowan. I appreciate that Gunnison Energy is willing to do that. I think that at the end of the day, this is an approvable location that has met the burden, and I agree with your reverse analysis in terms of this is where we've been placed and we should be making these decisions based upon the rules. Others with deliberative thoughts? Commissioner Messmer?
Thank you, Mr. Chair. Thank you both for providing your thoughts. I think there's a lot of things that you had indicated that I agree with. I think just a couple of other things to highlight here. A lot of the arguments that came forth, by CHC in this application really are arguments that they also brought forward during the mission change rulemaking. And the application of the geologic hazard rules and the analysis that was provided, really was something that was a result of their participation, not only CHC, but the other entities that are being represented by CHC in this particular application, but were a result of proposals that were brought forward by these organizations during the mission change rulemaking. And I think that Gunnison Energy, and I want to emphasize here, this is Gunnison Energy, not Gunnison. Gunnison is a municipality on the other side of the mountain. This is Gunnison Energy. But it is, they have met that obligation within the geologic hazard analysis and provided, I thought, reasonable and necessary mitigation measures associated with monitoring and with determining potential impacts and adjusting their operations and proposal accordingly. This is existing pads. I think it's more important to understand these are existing pads. These are existing disturbances in which these are being proposed on. There are existing pipelines that are being utilized in order to supply reused and recycled produced water from operations. This isn't a significantly big area like you may see in the northern parts of the Piceance. So when you start talking about recycled produced water associated with it, those recycling operations in the northern parts of the Piceance have significantly more wells attached to them that allow for a certain volume of produced water to be able to be developed that then can be utilized in new operations. The operation here, while certainly does have recycle capabilities to it and a certain amount of storage, doesn't have the number of wells tied to it nor the volume. And so I do anticipate that this operator will utilize all of the volume that's available to them in their operations, particularly understanding that they're going to be drilling and completing these wells in two different sightings. And so I would hope that there's lots of opportunity here for additional utilization. But I also note that the freshwater that they're anticipating on using is an industrial water right that they've acquired. And it's a water right that's available to them for utilization here. I think that while I'm very sympathetic to the situations that occur on the Terra Ditch, and in fact have toured and visited the Terra Ditch, unfortunately, the situations that are associated with that, as indicated in analysis that they've provided us during the mission change rulemaking and in the past, are due to, and in fact was testified as much in this hearing, unfortunately is due to legacy coal mining, in the vicinity and underneath that particular area that causes geologic instability and certainly creates some pretty challenging situations for the water users from that particular situation. I still have not seen any compelling evidence that there's a nexus between oil and gas activities miles away from this particular site and increases in geologic or seismic activity occurring that directly impact the Terra Ditch. And so I didn't find that nexus or that connection in the arguments that were made here in this particular application. I do know that as Commissioner Ackerman indicated, that there's no high priority habitat in this particular area. That the fluids and gas from this particular location are intended to be piped, and the sand that's being utilized in completion activities is accessed at least part of the way to this site utilizing rail. And that the nearest ag water takeout, at least as far as I can tell from testimony that was provided by CHC, is more than 5 miles away, and would be fed through this intermittent stream. And I think, as indicated, the oil and gas activity that's already occurring here doesn't appear to have created a perception of risk to the organic operations that are occurring in the area. And so I don't find that the argument that the utilization of existing pads in this particular area increases that perceived risk. And so the one piece that I will note, and I certainly appreciate Commissioner McGowan's request that there be communication between the operator and CHC or some of these other groups should there be a spill. You know, this was also discussed during the mission change rulemaking number of different times. In fact, these exact parties brought up this during the mission change rulemaking. I think there's an obligation for the local governments to be able to be involved in that, and so while if Gunnison Energy agrees to contact CHC voluntarily as part of this, I think that that's a good thing. I think it's important that operators interact with their neighbors. At the same time, I would expect that the city of Paonia or the town of Paonia and Delta County would also have opportunities for notice in particular situations where certainly the operator is obligated to provide them notice. Perhaps not this town of Paonia, but certainly Delta County. And so I think another option there is to have the town of Paonia request notice in these particular situations. And so those are my thoughts. I would be supportive of this application as it was presented, as I think it meets the obligations associated with our rules.
Further deliberative thoughts? Thank you, Commissioner Messner. Appreciate the thoroughness of this deliberations. Commissioner Cross.
Thank you, Mr. Chair, and I'll admit many of the comments that I had prepared have already been touched upon, so I'll be pretty brief. First of all, I think it's also important to note that BLM has already taken an effort to issue an APD for this, and so therefore they've already looked at existing NEPA analysis, both at a more comprehensive level and then also at the site specific level to see if anything would change their views on it. And the fact that they issued it, I think, is also noteworthy. I do think that this application is protective of public health, safety, welfare, environment, and wildlife resources for many of the reasons that Commissioner Messner just identified. Like he said, I think one of the things that stuck out to me is that this is an existing location. We're not doing new disturbance. We're not, building new roads. We're not doing anything like that. It's not high priority habitat. It's not within a disproportionately impacted community. There's no RBUs nearby. It's using pipeline takeaway for water and for gas. It's taking efforts to minimize truck traffic. I think when you look through the BMPs that the operator is proposing here, these are quality best management practices designed specifically to take efforts to avoid, minimize, and mitigate impacts, whether it's air emissions, dust emissions, light emissions, spills, etc. And so from that standpoint, I am in favor of this. I do want to talk briefly about some of the arguments that were raised by CHC in this. And I want to say, kind of starting from a broad-based aspect, I think a lot of what we heard, both in the briefing that was provided as well in the testimony that was provided, was not that, as was mentioned before, it's not that the operator here has not met our standards. It's not that the operator is not following our rules. They don't think that they've gone far enough. And I think a lot of what we're seeing here of some of the arguments of, yes, they did look at this, but they didn't take into account. I think one of the arguments was with spills and releases, they didn't take into account warming and climate changes in terms of the probability of spills and releases. And to me, those kind of arguments are NEPA-based arguments. And that kind of argument is exactly, as we look to the cumulative impacts work we're doing, one of the concerns that I have with focusing on a NEPA-based argument. It's not that rules are being met, that our procedures are being met, it's that they want additional analysis. And I find it difficult to really draw that line when you get to that. And that's why we have substantive-based rules where we have set procedures. Did you follow the procedures? Have you met all the guidelines? That's what we're focused on here, not a procedural of we could have done more, we could have looked at more, we could have analyzed more, and because of that send it back. And so I think from a big picture, that's one of the things that I wanted to point out. With respect to some of the specific arguments that were raised, appreciate Dr. Meckel testifying to us and providing his input on this. I wanted to note a couple things about that testimony. For one, the discussion of the quantifiable impacts as opposed to the qualitative impacts or likelihood. One of the things that stuck out to me is that Dr. Meckel indicated that it was a reasonably acceptable standard, not that this is what's expected, but an acceptable standard to require some kind of quantification here. Whereas what we see in our rules is an indication of a description of whether it's low, moderate, high, etc. And I think when you actually look through the plans that were provided, the geological hazard plan, you do see that quantification that he's talking about. Now, I don't think it is tied into what he's saying of the likelihood of this happening one time every 5 years, therefore equates to low or therefore equates to moderate. Instead, what you see is specific information such as this INSAR study talking about going beyond the 1 mile radius that's required, by the way, but looking at things that saying it's able to detect any kind of identify with confidence a velocity of greater than 4 to 5 centimeters per year. And specifically identifying what we're seeing within this 1 mile radius is this 2 to 3 centimeters a year, or less than 2 centimeters a year. And at that rate, it is not likely to have landslides. It's not likely to have that subsidence. It's not likely to have the persistent landslides that were discussed. And so while I don't think that they tied in the specific numbers to saying this number equates to low, this number equates to moderate, this number equates to high, the report specifically does go through and identify with quantitative information the chances of landslides, of avalanches, of unstable slopes, of spills, etc., and really discusses the fact that based on that information, this is why we described it as low. And to me, I think that that is also a reasonably acceptable manner of defining exactly what's required under our rules. And again, I think when it comes to the spills that were talked about by Ms. Shank as well, I think it's one of the things I wanted to understand from that is if it was a concern about flow lines, if it was a concern about actual downhole spills or leakage. And I think that one of the things that's important for the public to know as well is this is part of the reason that we went through a flow line integrity rulemaking process to make sure that we have the best flow line regulations out there, making sure that we have BMPs to make sure that the flow lines are protected. It's important to note that some of the BMPs here specifically talk about protections such as automatic shut-in, talk about remote capabilities of determining if there's any kind of pressure differences, because that's exactly the kind of information that will signify that a spill is happening. So even if something has spilled underground, if we're seeing a difference in the pressure within these flow lines, seeing a difference within the pressure within the wells, this is the sort of information that is indicative of a potential spill, and that's what causes the automatic shut-in. So that's exactly the kind of material that the operator looks at to make sure that they go and take care of this as soon as possible. So there's not spills that are occurring underwater, or sorry, under the subsurface that aren't detected purely because it's not visible. And so I thought that was important to note as well. But again, I think that when you look at really, aside from the consultation aspect, which I'll touch on briefly in just a minute, I think aside from that, really the request that we're seeing from CHC here is, and even what Dr. Meckel testified to, is they've done a good job of using the INSAR to create the baseline information. They've done a good job of identifying best management practices, but what we'd like to see is more. We'd like to see, describe what the worst case scenario is there, and then maybe design your avoidance, minimization, and mitigation measures around that. Not that the BMPs are not sufficient, are not reasonable and necessary to protect public health, welfare, safety, environment, and wildlife resources. And then just quickly, one last point, because I don't want to belabor it, because I agree with Commissioner McGowan, I agree with Commissioner Messner. I think that it is great if we can get agreement with the operator to disclose any kind of reportable spills. I think that's a good step to being a good neighbor and a good member of the community. But I'll just say, also with respect to what Commissioner Messner was saying, I think that if CHC and its members are really having concerns with what Delta County is reporting or letting the public know about, I think the appropriate group to talk to at that point in time is Delta County, not to come to us and say, make them do it, even though that's not what's required under your rules, because Delta County's not doing it. That makes it seem like CHC and its members should be talking to Delta County and saying, hey, these are some of the concerns we have. We think we should be notified when you're notified. And I think that that's an additional step that is probably worth taking as well.
Thank you, Commissioner Cross, for the deliberative comments. Further deliberative comments? Or does anyone care to make a motion?
I'd move for approval of the application, and AAG Mercer. I don't know if maybe here it's appropriate to also add in the agreement from Gunnison Energy to include the notification to recognize CHC point of contact or not here, but so maybe it's appropriate to understand that first.
Thank you, Commissioner Cross. I do think it would be appropriate, if it's the Commission's desire, to have that agreement firmed up to include a BMP or condition of approval on the 2A. And the way that I understood what the operator has agreed to, but would certainly welcome corrections from Mr. McGowan, would be a BMP along the lines of, the operator will provide notification of any reportable spill within the applicable reporting timeframe to one contact designated by Citizens for a Healthy Community using contact information provided by CHC. Suggest a COA along those lines.
I would move for approval of the application with that COA as described by AAG Mercer, unless Mr. McGowan has concerns with the wording of that COA.
Second.
Okay, we've got Mr. McGowan, are you comfortable with the wording of the motion? You're muted.
Sorry, just so we're clear, but we want to make sure it's limited to the wells on that pad, as reportable spill to the pad, and maybe I need to make that clear, but we just want to make sure that's, if it's to the pad, was a correction that was passed on to me. So if it happens on that pad in the location that's applicable to this permit, and we can work on the language if you're comfortable with that. But that was the one correction I just wanted to make sure.
Yeah, I think that's been the intent all along, as we're dealing with the proposed wells on this pad.
If necessary, also amend.
Okay, we have a motion and a second. Is there further discussion? Seeing no further discussion, all those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? Motion carries unanimously. All right. Once again, always like to end by thanking the invisible staff that's behind the scenes that does all the great work that gets these applications to us. it is a voluminous task, and we really appreciate that work on the part of our excellent ECMC staff. And to thank the operator for putting together a good approvable application. And finally, to thank CHC for their involvement here. I think they raised concerns that we know are near and dear to them, and I hope that they understand that the action today is trying to balance a lot of the things, as Commissioner Ackerman pointed out, and hope that they will engage with Gunnison Energy on getting the notification person identified early on and often. With that, I'll look for a motion to adjourn.
So moved.
Second.
Motion and a second to adjourn. All those in favor signify by saying aye.
Aye.
All right. Don't have a meeting next week. It's Thanksgiving. Everybody have a nice holiday, and we'll see you the following week.